Oh, hey there, folks. Elder Law Care Attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, today's question is, what is the importance of elder law planning? Folks, there are 12 areas of elder law. It runs the gamut from power of attorney to healthcare proxy to Medicare and Medicaid and Social Security law and so on and so on and so on. So really, really important, folks. What is the importance? I always say to my clients, use the metaphorical four-headed beast as a formula when you're assessing and evaluating your particular circumstances. Number one, will my assets avoid probate court when I become disabled and when I die? Okay, folks, tough question. And the general rule is this, folks. If you have any asset that is titled in your name individually, and you do not have a joint owner, and you do not have a proper beneficiary designation specified on that account or contract, that asset will go off to probate court when you pass away or become disabled. I call that disability probate. So really, really important, folks, the importance of elder law, especially if you're in the third quarter, fourth quarter of life. Put a meaningful disability plan in place. I refer to it, folks, as the Big Six disability planning. And I'm going to run through that with you. And you can also find an article on our website where I talk about this called the Big Six disability planning. Go to elderlawcare.com to learn more on that. But let's run through the importance of the Big Six disability planning. Number one, folks, durable financial power of attorney. So important for you to create that, especially for folks 65 and over. Really, really important, in my opinion, to have a power of attorney, a durable power of attorney with enhanced elder law powers. Enhanced elder law powers. What are some of those enhanced elder law powers? Well, folks, you may want a power to gift, a power to give gifts, or give your attorney, in fact, agent, either your spouse or your trusted child, that power to make gifts. Why is that important, folks? Second-headed beast. Well, if you're going home on hospice someday, like my dear mom did a little over 2 years ago, and if you have a taxable estate and you want to spend down that estate, reduce the value of your estate to minimize or avoid the estate tax, really, really important that your power of attorney, your attorney, in fact, have gifting powers. So that may be an enhanced elder law power. Another enhanced elder law power is what we call self-dealing. So under the Uniform Power of Attorney Act, my understanding is that a power of attorney agent cannot engage in self-dealing unless it's specified in the four corners of the legal document, giving them authority to do such. What would be self-dealing? Well, maybe your son or daughter is your attorney in fact, and you want them to spend down your estate later in life to reduce the estate tax, to put more money in the pockets of your beneficiaries and not the tax man, so to speak. Well, you better make sure that your attorney, in fact, number one, has gifting powers. Also, number two, has powers to self-deal, to maybe make gifts to themselves. But folks, I want to caution you, you really, really have to trust that person, that attorney, in fact, unconditionally. So that's an important condition for you to make sure you trust your power of attorney, your attorney, in fact, unconditionally, before you give them these big powers. Another enhanced elder law power would be letting them deal with and fill out government applications for Medicaid benefits. Could be for Medicaid, could be for, here in the Commonwealth, we call it Mass Health. If you become completely incapacitated and you need, or your loved ones need to apply for Medicaid or Mass Health benefits on your behalf, you want to make sure your attorney, in fact, has those powers within the four corners of your power of attorney to do such. Also, maybe deal with other government entities like the Social Security Administration, maybe the Veterans Administration as well. So really, really important powers to have. Another important power to have is a caregiving contract. What if you're completely incapacitated and you do not want to go into the nursing home? Maybe you can still reside in your own home, but you need assistance. And maybe you have a family member who has a medical background, maybe a nurse, who can render care for you as your caregiver. And maybe you can pay them to take care of you. Well, From my understanding, oftentimes if you pay them without a proper caregiver agreement in place, and then if you have to go into the skilled nursing facility and you need to apply for Medicaid benefits, the Medicaid authority caseworker could construe the money that you're giving that family member or friend as a caregiver as a gift or an impermissible gift, which we'll talk about soon in another video. And if that money's paid to that individual is construed by the Medicaid caseworker as a gift, that will create what they call a penalty period, which will typically deny you the benefits. They'll pull out their denial stamp, deny the Medicaid application, and that person will either have to cure that penalty by repaying the money that you paid them, or wait a period of time called the penalty divisor period before you can reapply for those Medicaid benefits. So folks, that is just some examples of enhanced elder law powers. So back to the Big Six disability planning, really, really important to have that first one, the durable financial power of attorney, in a time of disability to avoid conservatorship proceedings at the courthouse. You want your loved one to be able to legally step into your shoes day number one to manage your financial affairs for you. I often say your worst pick is often better than the probate court's best guess. They're very professional, they do a great job there, but they're very inundated and very, very busy. And unfortunately, sometimes they don't get it right. Folks, number two of the Big Six is the healthcare proxy. And I'm not referring to that one pager that you put together when you're going in for your knee or hip surgery. I'm talking about a more robust, more comprehensive healthcare proxy, we call it here in the Commonwealth. Some states refer to it as a healthcare power of attorney, where you're appointing your loved one, your suitable individual in your family, perhaps, or your best friend to be your healthcare agent, somebody with a medical background maybe who can legally step into your shoes as your surrogate and make your healthcare decisions for you should you be unable to make that decision yourself. So important to have that, folks. If you don't have that, your family or loved one could be faced with petitioning the probate court for what they refer to as guardianship, formal guardianship. That's why I call those processes the stresses and messes of probate court and the economic and emotional headaches of probate court. Why? Because conservatorship petition, guardianship petition, they can take months and months and months and cost thousands and thousands of dollars, folks. Third of the Big Six, folks, is the cousin to the healthcare proxy called Advanced Medical Directives, where you can spell out in writing what type of care you want specifically in a time of incapacity. For example, situation A, you're in a coma, no chance of recovery. What type of care would you want in a situation where you're in a coma with no chance of recovery? Do you want a feeding tube? Do you want to be intubated with a feeding tube? Do you want artificial nutrition and hydration? Do you want CPR? Do you want pain medication? And so on and so on. Really important to spell those wishes out. So your healthcare agent can make those decisions with the utmost confidence and also avoid the family drama and trauma with money more than quarterbacks saying you shoulda, coulda, woulda. So you want to avoid that, folks. That Advanced Medical Directives, from my experience, is designed to avoid conflict, not only with the medical professionals who are educated and trained to sustain life, also designed to avoid trauma and drama with whom else when emotions are running high. That is correct. Other family members. So have it in writing so your healthcare agent can follow your written instructions that you memorialize with your elder law attorney in writing in a time when you're alive and well. So when you're alive and not so well, it's all spelled out for you. Number 4, folks, HIPAA Authorization, Health Insurance Portability Accountability Act of 1996. This is the privacy confidentiality laws. Really, really important that you have that in your back pocket. I talk about it in the book, the importance of that, and it's often overlooked from my experience in an estate plan. Really important that your loved one can step into your shoes, but also get access to medical records if they want to obtain a second opinion from a medical specialist. Number 5, folks, is a living will. Some folks refer to it as a expression of your wishes, a living will, or a DNR, do not resuscitate. So that's really important if you want those steps taken end of life. If you're in a catastrophic illness or coma, you're basically saying, I don't want to be hooked up to any machines or tubes and so forth. And number 6, folks, what I refer to as the newest of the Big Six is a Spoonfed Directive, based on a case out of New York State that there was a retired nurse later in life who had dementia, and she had a healthcare proxy. Well, the healthcare proxy was silent. It didn't spell out whether she wanted to be spoon-fed or not. From my understanding, it's fairly standard medical protocol when an incapacitated person, maybe with dementia in a skilled nursing facility, is no longer eating under their own volition. The staff is trained to pick up a spoon and manually spoon feed that person. That is correct, folks. They're trained to pick up that spoon and manually spoon feed that person. If you don't want that type of care later in life, if you're completely incapacitated with no quality of life, really, really important, in my opinion, to make sure your elder law attorney works with you to create that Spoonfed Directive, the one we create for our clients at our Elder Law Care Center. Option A, you basically say, hey, no spoon feeding if I'm no longer eating under my own volition. Option B, maybe spoon feeding me so long as I'm not choking on the food or aspirating on the food or pushing the food away. So there you have it, folks. Big 6 disability planning. I'm going to throw one more in as a bonus. This is a pro tip. We call it here in the Commonwealth a MOLST form. Nationally, they call it a POLST with a P. So we'll talk about the POLST. Physician's order regarding life-sustaining treatment. Or in the Commonwealth of Massachusetts, we call it medical order regarding life-sustaining treatment. And that carries a lot of weight and authority. Why? Because it's a medical order regarding life-sustaining treatment. Hence the reason why they call it MOLST, M-O-L-S-T, or POLST, physician or provider's order regarding life-sustaining treatment. Carries a lot of weight because typically signed off by an MD medical doctor or an MP nurse practitioner, and that might be most appropriate when you have less than a year to live, or somebody like my dear mom a little over 2 years ago that was diagnosed with a brain tumor and she courageously went home on hospice. So there you have it, folks. That is a part of elder law, and that is disability planning. Disability planning often comes before the drop or before completely checking out or going up to your cloud. I often say, unlike fine wine, unfortunately, we don't get better with age. So really, really important to put your disability planning in place when you're alive and well, as well as other parts of your estate plan to plan, folks, against the four-headed monster. Avoid probate court, avoid the taxing authority for the estate death tax, or it could be even capital gains tax. And folks, financial creditors and predators, protect what you worked hard for the people you love the most. And of course, folks, ask yourself the question, if either you or your spouse became completely incapacitated at some point in life, they say 70% of people 70 and over will need some level of long-term care someday. I've seen it professionally. We see it all the time at our Elder Law Care Center. I saw it sadly enough with my dear dad, who ended up in a nursing home later in life and passing in the nursing home. And my dear mom a couple of years ago, almost possibly going into a nursing home, but courageously making a decision. I do not want chemotherapy. I do not want radiation. I do not want the brain surgery to remove and extract that brain tumor. Send me home, she said courageously, on hospice, and that's what she did. So folks, take action when you're alive and well. Don't wait till the fourth quarter of life. Take action in the third quarter, maybe even halftime or second quarter, even better. But that is the importance of elder law. Nobody's going to make you do it, folks. I talk about that in the book. The government doesn't mandate or require that citizens put together an estate plan. The responsibility and the onus is on you, folks. I hope this video was helpful, folks. If you have a loved one who is looking at putting together an elder law plan, I strongly encourage you to work with a qualified estate planning elder law attorney who's going to work with you to learn about the family. They'll teach you about the law, and you teach them about the family. I often say that to our clients. You're the expert on the family. Your attorney should be the expert on the law. The deal is you work together to co-create that plan to achieve your goals, your dreams, your vision, what I refer to as the front side of the cloud, family harmony, and avoid the back side of the cloud, family harm. Folks, if this video is helpful, please scroll down, leave a comment. A member of our Elder Law Care team will get back to you as soon as possible. If you found this information helpful, folks, please subscribe to our YouTube channel and share this information with other folks that you think also could benefit from this information, folks. If you want to learn more, folks, go to our website, elderlawcare.com, and pick up a copy of the Four-Headed Monster book on Amazon, How to Slay the Metaphorical Beast, the Four-Headed Monster. Thanks for being here. Elder Law Care attorney Patrick Kelleher. See you next time at elderlawcare.com.